Mr. Beachy, would you come up and have a seat, please?
Mr. Beachy.
Our next matter we're going to address is People versus, well, wait a minute, is the complainant here?
She's in the hallway.
This case starts like a routine pre-trial, but within moments, it spirals into something far more complicated. We've got domestic violence allegations, a pending eviction, conflicting claims about property and personal belongings, and a legal strategy that could completely reshape the outcome. The defendant is facing 2 criminal counts, but instead of heading straight to trial, there's talk of rehabilitation, negotiation, and possibly wiping the charges clean. The question is this a genuine attempt at accountability or a strategic move to avoid conviction? And as tensions rise between both sides, one thing becomes clear. This courtroom is about to untangle a situation where criminal law and personal conflict collide in a big way. Stay with us, because the details matter here.
Move to the back, please. No, this is.
That's the attorney's side.
But you're not going to be close to my complainant.
Oh, good afternoon, Paul. We're happy to see you.
So I've got it. I've talked to 2 of the people know what they want to do. I don't know if should I wait till I talk to the other 2?
Yeah, go ahead. We've got another matter we're addressing. So, but when you get here, we'll be ready for you.
Okay.
Very good. He's back from the jail. Anyway, let's restart. This is a final pretrial before jury trial in the matter of People versus John Mark Beachy. That's you, sir? Of course, I know who you are, but I have to identify you for the record. The file number, if I didn't say it, is 26-42SM. The matter alleges 2 counts of domestic violence, which occurred allegedly on January the 9th. The complaining witness in this case is Megan Sudbury. Prosecutor is represented by Angelique Campfield, and Mr. Tom Siver is here. We see a lot of Mr. Siver. Years past, but I hadn't seen you in a long time till you got this matter. I know that you guys have been talking seriously back and forth. Mr. Siver, you're at the podium, so I'll defer to you. What's the status here?
Judge, I believe that we have a request of the court. We'd like to adjourn off the trial and adjourn the matter to a date later on. In the alternative, Mr. Beachy will begin a program recommended by the prosecutor. The prosecutor has indicated that if that program, if the person that runs it reports that Mr. Beachy is engaged in the program and making progress, then she will consider a different offer. If you'd like, we can put that different offer on the record.
No, I think
I wasn't sure.
we're all right. Well, maybe so. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. There are 2 counts alleged here. There is a special type of probation that is available in domestic violence cases where the defendant could be placed on a probation, and if the defendant successfully completes the probation, the charge is taken off his record as a public record of conviction. And we can only do that if the prosecutor consents. And so that's often an issue sometimes in other types of cases. The court can do it on its own discretion, but in a domestic violence case, the court can only do a deferral if the prosecutor consents, under, I guess, the theory that they know more about it at that point than the court does. I don't have a terrible problem in adjourning this, but I don't want to go too far. there's another factor, the parties are aware of it. I don't know if you guys are. There's a landlord-tenant case tomorrow. Mr. Beachy is moving to terminate the tenancy of Miss Sudbury. This incident occurred on Mr. Beachy's house on Thompson Lane, and apparently Miss Sudbury is living in another house across the lake from Mr. Beachy's house. Is that correct?
I have no clue.
Well, Mr. Beachy, do you own the other house on
No.
Resort Road?
No. That's where she went to after she left my house.
All right. Uh, I thought it was you doing the eviction. Maybe it's somebody else.
No, I'm doing the eviction.
All right. Do you own that house?
I own 55275 South Thompson Lane,
All right. Who owns the Resort Road house?
Jeff Glass.
And which house are you evicting her from?
My house.
All right. Then I guess I didn't read the pleadings carefully enough. All right. So there's a no contact provision. So are you out of your own house?
I was out of my own house. She went to be at Jeff Glass's house on January 23rd, and she hasn't been back since. So then a week later, I moved back into my own house.
All right. So there was a period of time your children live at your house.
Yes, they do.
So where were they?
They were still at my house.
There's an odd set of facts.
Yes,
You're fine. Some of this I knew and some of it maybe I didn't. So there is a termination of tenancy case. There's no lease. And so at this point, tomorrow you'll be asking me to get the rest of her stuff out of your house. Is that correct?
yes, sir.
All right. And we'll deal with that tomorrow. But it happens more than a little bit. In a domestic violence case, there's almost always a no contact provision. And on some occasions, several times a year, the owner of the house actually gets put out of their own house. But it doesn't prohibit them from pursuing a termination of tenancy action. The landlord-tenant judge and the criminal judge, sometimes those two things interact. I get all the PPOs that either have a domestic violence contingent or a landlord-tenant contingent. There is no PPO here, but
There is, Judge.
is there a PPO? All right, well then.
The
maybe
PPO was
that's-
addressed by
By Mr. Pattison.
Yes, sir.
All right, well, we'll deal with the landlord-tenant case separately.
Give you a full status on that. That was adjourned without date.
Okay.
Mainly because Judge said that he wasn't inclined to lift a PPO as long as there was a criminal case open. So we adjourned without date in order to resolve things in order.
Well, at this, it's less urgent since he's back in his own house. All right. So, Ms. Camfield, how long are we talking about adjourning this?
Your Honor, that is something that is really within the purview of I don't want to say the purview fully of the defense. The program that I was speaking with Mr. Seaver about for his client was something that I indicated I would consider, but I would not guarantee a change of my current offer. I would think that at least 4 sessions of that program would be enough for the instructor and therapist to notify me of whether there's sincere participation or just presence.
All right, well, at one time, domestic violence cases were supposed to be fast-tracked by the court. They were supposed to be resolved within 78 days of the arraignment, which wasn't always easy to do. So we already had an adjournment because of the medical issue. We lost a month. And it's not in anybody's interest to drag this out, but defendant wants to avail himself of an opportunity to prove himself. I'm going to continue this for a final pretrial for April 30th. Snow will be melted by then, we hope. At 2 o'clock.
Yeah, it may be a little bit unusual, but given the convoluted facts in the tenancy and pending eviction and things, may there be an amendment to the criminal order that none of the complainant's property be damaged or moved from the premises without the order of the court?
No, obviously it can't be damaged. This is a tenancy that needs to come to an end. There's no lease. She's not living in the house, not paying any rent, and the defendant wants some closure.
Judge,
I'm not going to use a criminal case to forestall a termination of tenancy case.
my clients informed me, I didn't know about the hearing for tomorrow, but my clients informed me that the property is no longer at the physical location.
All right, so it may be a fairly straightforward proceeding. If she's gone and her property is gone, there may not be much to fight about. The way it would work,
But I didn't even know there was a landlord tenant that had been filed.
the way it works now, a plaintiff serves a notice to quit on a tenant. Says, I want you to move. I want you to move by a certain date. In this case, 30 days. The defendant doesn't move, so the plaintiff files a termination of tenancy lawsuit, which is what this is. They want you to move. They have a hearing in front of the judge. Before COVID, generally, the judge would give you 10 days to move or you would be subject to being evicted. Now, we have to adjourn the matter at least 7 days for the defendant to have an opportunity to seek legal advice or emergency financial assistance to pay the rent. But in this case, he's not asking her to pay the rent, he's asking her to move. So tomorrow's hearing would be March 20th. It will be adjourned till March 27th. And the defendant would have 10 days from that day to vacate or be subject to being evicted if Mr. Beachy gets what he asked for. So this is a long process. Landlords are very frustrated, but if Mr. Beachy gets what he asked for, the defendant would have until April 7th to vacate or be subject to being evicted. But it sounds like she's already vacated and her stuff isn't there.
Your Honor,
Yes.
It's not a matter that the prosecution's involved in, but I'm being informed that she does not have her property. It has not been returned and she's not at the premises because she was locked out of the premises. I just want that on the record.
All right,
I
well,
have no
there's
knowledge of that other than my client told me that the property is not at the physical property anymore. That's all I know.
all right, well, it may be, you can't do that. There's an anti-lockout statute.
I didn't do that, Your Honor.
All right, well, we'll hear that in the context of tomorrow's case. As a practical matter, I don't think she wants to move back there anyway. She just wants her stuff. And maybe we can accomplish some of that tomorrow.
But like mine, Your Honor, also, like she took my driver's license and all, and
This
All right, well, that's,
is not appropriate.
that's, I'm not sure what that is. This isn't a civil case for possession of property. But let me ask this. So you don't have your wallet or your driver's license?
And then I applied for a new one, and then that one ended up coming up missing out of the mail up as well.
Well, we don't know about that.
Which they did take.
Again, I don't want to get too much into the facts, but it's a huge pain in the neck not to have your wallet or your driver's license. I'm assuming you don't acknowledge that do you acknowledge that you have his wallet and driver's license?
No, I don't.
All right, that was all right. Well, that's not what's before the court, but that's divorce kind of stuff. Fortunately, I don't do that. Now, this isn't a divorce, but it's a breakup of a relationship of a year or so. Anyway, we'll sort out tomorrow about the property. What we're doing today is we're adjourning this about 6 weeks, April 30th. The defendant, I assume, is going to start an anger management or domestic violence treatment class and participate sincerely, and we'll leave it at that. And the prosecutor may reconsider what their current offer is, which I don't know. Anyway, we'll hear more about that tomorrow. Nobody's under oath. Now, tomorrow's hearing is by Zoom. Either one of you are welcome to come live and in person. The hearing's at 9:30 tomorrow, I believe is the time. I'll be here. You can Zoom in or you can come here live to the courthouse. Either way, we'll address the landlord-tenant matter tomorrow. And the PPO matter apparently is standby. So this matter is adjourned to April 30th at 2 o'clock. Hopefully some progress can be made, and we'll address the property issues tomorrow in the landlord-tenant case. When you say wallet, did it include credit cards and all that sort of thing? All right, well, obviously doesn't acknowledge it, but it's not what I'm here for. We may inquire further about it tomorrow. All right, you're free to go, and then we'll wait and let the complainant go. Mr. Cyber, I'll see you on April 30th.
What's that, Judge?
I said, Mr. Cyber, I'll see you on April 30th.
Thank you, Judge. Have a good day. Good to see you.
All right, thank you. Good point. I said I'm gonna turn this off, and I'll forget to turn it back on. We did make a record without having the record on in the matter of Frank Darren Randall, file 252691 SM. Mr. Randall is represented by Mr. Paul Gibson. He has failed to appear. He has at least 2 previous assault charges, one from 2018, one from 2021. He is not here. The complainant was here. So the bench warrant is $1,000 cash or surety, the 48-hour hold. Next is Autumn Susan Lane. That's you?
Yes, sir.
Ms. Lane, you're charged with 2 counts of domestic assault. You're here with your lawyer, Mr. Paul Gibson. Also present is Assistant Prosecutor Angelique Canfield. Ms. Canfield, what's the status here?
Your Honor, we offered as a final resolution for a plea to 1 count, dismiss the other. And my understanding is that that has been rejected and a trial is still sought.
Was there a deferral in there?
No.
All right, and Mr. Gibson, that's not satisfactory to your client.
I conveyed the offer to her, and
Well, it is. It's essentially plead as charged.
Well, there's 2 counts, Your Honor. I offered 1, dismiss the other.
That really isn't much of a distinction. They would be concurrent, and they would be still subject to 93 days in jail and a fine of up to $500. I don't know that you're not eligible for a deferral, but they're not recommending it. And as I said earlier, I can't do it without their blessing. let's talk about what we got. We've had some issues, as you saw recently, with getting witness lists and exhibit lists. We used to always nail them down right here. But Judge Patterson had some concerns where they were expected and none got filed by either side. So let's talk a little bit about some of the evidence here. Do we have any video evidence or anything?
Not that I'm aware of, because I didn't, there may be body cam, I suppose, of after the fact.
All right.
I'm looking now.
Or medical evidence or anything like that?
There are body cam and videos that were in Axon that have been made available. I don't see any medical records in the file. I show a potential of possibly 5 witnesses.
All right. All right. Do you have any witnesses you may wish to call, Mr. Gibson?
Well, the defendant would be on the witness list. I don't know if the witnesses, I guess I would want to see the prosecutor's witness list to see if it's naming the same.
Well, you can always name them anyway. You have 21 days to file witness and exhibit lists. Looking at our trial calendar, as I mentioned, we haven't yet tried a case this year, but we've got some cases that are kind of stacking up. We lost March because of my absence. We're losing April because of the construction. And May 6th is the drug treatment court conference. So May 20th, we have Mr. Pontius, Ms. Hahn, and Mr. Palmer. That won't work. Then June 10th, we have Jordan Harden and Tim George set. So we're going to set this for trial for June 24th. At 8:30 a.m. Miss Lane, you've got some unpaid fines. I had it right in front of me. Here it is. Bill $150 on a retail fraud charge. They sent you a plea letter. It looks like it's a civil infraction. Do you have any knowledge of that?
Yes, I do.
All right. I'd like you to stop out at the counter and check into that before you go.
Okay.
That is file number 26450N. All right. Are you at the Everson Drive address?
No, that is my parents'
And you have
address.
a no contact?
I gave Mr. Gibson my current address, which is Keystone.
All right, make sure you keep them apprised of any changes. She's got a fingerprint order on here. Did she get printed? All right, very good. Do you have any questions?
No, sir.
All right, I want you to stop out at the counter and see those ladies about the retail fraud
Okay.
case. All right, you're good to go.
This hearing may not have delivered a final verdict, but it set the stage for everything that comes next. The court has officially adjourned the case, giving the defendant time to enter a program that could potentially reduce or even reshape the charges. At the same time, we've seen how parallel legal issues, like eviction and property disputes, can complicate a criminal case, adding layers of tension and uncertainty. On the other side, a separate defendant has rejected a plea deal and is now heading toward trial, where the stakes remain high with potential jail time on the line. These decisions, whether to negotiate, fight, or comply, can define the entire trajectory of a case. So what do you think? Was the court fair in giving more time, or should this have moved faster toward trial? If you found this case as intriguing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more in-depth courtroom breakdowns.